Welcome to Brief Encounters and the September episode of the Securities Regulation and Enforcement series. My name is Valerie Mirko. I'm a partner at Armstrong Teasdale, as well as the leader of the firm's Securities Regulation and Litigation practice. And I'm very excited about this episode. With me is my co-host, William Nelson, who will introduce himself as well as our guest.
Yeah, thanks so much, Valerie. And I am 100% with you. I think this is going to be a great episode. My name is William Nelson. I'm the Director of Public Policy, Associate General Counsel for the Investment Advisor Association. And we are so fortunate today to have with us David Adams. He's a partner at Mintz, has been a regulatory enforcement attorney with over 20 years of experience in the financial services industry. And specific to this episode, he has unique experience in advising broker-dealers and investment advisors on crypto asset operations. So again, David, thank you again for taking the time to be with us today.
Yeah, absolutely. Thanks to both of you for having me.
Yeah, so let's just jump right in. You could say there's been a little bit of a change in how crypto assets are viewed, both by the current administration, which would also include the SEC, Department of Treasury, other federal regulators. So can you just kind of talk about, kind of set the table where we're at today, and how does the SEC and FINRA kind of currently view crypto assets, when they're held or being used by investment advisors or broker dealers?
Yeah, so I think there's been quite an evolution in the SEC's thinking over the last couple of years on crypto assets, and quite a thawing, I think, in the approach to crypto assets generally. I think for investment advisors, I'm going to break it between investment advisors and I'll talk about broker dealers in a minute. For investment advisors, I think the thing to remember when you're talking about crypto assets is that all of the same fiduciary duties that apply to investment advisors with respect to any product and their clients apply to them when it comes to crypto assets. So the SEC is going to continue to treat crypto exposure as subject to an advisor's duties of care and loyalty. So you need to be doing product due diligence, suitability considerations, looking at fees and conflicts, considering valuation issues, et cetera. The SEC's Division of Examinations, also in its most recent priorities, noted that crypto was going to be a focus area for it. So to the extent that you're in the crypto asset space, I think as an advisor, you need to have heightened awareness, because it is an area that the SEC is focused on and is going to continue to focus on. I think when you're talking about holding the crypto assets, the SEC custody rule remains the baseline. As many listeners may know, there was a 2023 safeguarding proposal that was essentially withdrawn in June of 2025. So at least as of now, we are still sitting with the existing Advisors Act custody rule, or Rule 20642, that has been in place for many, many years. However, interestingly, just very recently, the SEC put out a regulatory agenda for spring of 2025. And one of the specific things on that agenda is going to be modernizing custody requirements for investment advisors, and specifically taking a look at crypto assets, which is something that we, as well as many organizations in this space, have been pushing for a long time, just to really understand how custody and frankly some other assets fit within the custody rule. Finally, if you're an advisor and you're thinking about getting into crypto assets, and I think we'll be talking about this a little bit later, but probably the cleanest approach is to go in through a variety of exchange-traded products that have come onto the market. We've got spot Bitcoin and Ethereum ETFs, and those exist within the existing regulatory structure. And so many times, I think, are the most approachable entry point and the cleanest way for an advisor to start experimenting with crypto assets. For broker dealers, things have also been pretty interesting. The SEC's Division of Trading and Markets put out some FAQs earlier this year, looking specifically at custody and something called the Customer Protection Rule, or 15c3-3. And while the guidance, I think, was helpful, I think it still left a lot of questions in people's minds, including whether or not there's something called the Special Purpose Broker-Dealer Rule, which allows broker-dealers, at least through the end of this year, to rely on a safe harbor and to cut both custody and execute transactions in crypto asset securities, but it also places some pretty restrictive requirements on those broker dealers. And a number of broker dealers have gone the special purpose broker dealer route, including some of our clients. But it's going to be interesting to see whether the SEC continues that treatment and extends it into the future, or if they do something completely different, or maybe extend it on a temporary basis until they put some additional rules in place. Because again, going back to the SEC's recent spring 2025 regulatory agenda, we also have on there amendments to broker-dealer financial responsibility and record-keeping rules. One thing I'll note real fast about the rulemaking agenda is that while there are dates on that agenda, for example, both of the proposed rules that I just talked about they say they're going to shoot for April of 2026, but those are never hard and fast deadlines. So it's possible we can see something before, it's possible we can see something after. Sometimes you never see the actual proposal. But overall, I mean, I think that if you're getting into this space now, you just want to be thinking about that it continues to be a space in flux and that there do continue to be a lot of regulatory questions. But I think the good news for people interested in crypto assets is we seem to be moving towards more clarity, certainly than we've had historically.
Yeah, and that's incredibly helpful, David, kind of setting the table. You touched on the most recent rulemaking agenda from the SEC, not surprisingly, being very crypto heavy. We've seen the SEC publish guidance on everything from meme coins to mining of crypto. And we've talked a little bit about some of the different rulemaking proposals, the prior safeguarding rule. It does look like they're going to address custody. What else do you expect from the SEC? We've already heard Chair Atkins talking about this whole Project Crypto, which does sound cool. So, we'll kind of see what happens there. But what do you kind of expect from the SEC rulemaking kind of over the next 6 months, especially juxtaposed with the staff attrition we've seen that, when you lose up to 15% of your workforce, you obviously, have less bandwidth. So just curious on your thoughts on that.
Yeah, 100%. So, and just to touch on a couple of the other crypto asset, at least the things from the spring 2025 unified agenda that I'm excited about, in addition to the custody rule and the amendments to the broker-dealer financial responsibility and record-keeping rules, there are also supposed to be proposed rules on crypto assets themselves. So rules on the offer and sale of crypto assets, potentially including new exemptions and safe harbors. There's also a proposal for crypto market structure amendments to account for trading of crypto assets on what we call alternative trading systems, ATSs, and even larger national securities exchanges. I think we're already seeing some movement towards allowing national securities exchanges and others to facilitate the trading of spot crypto assets like Bitcoin, et cetera. So I think we're going to continue to see that type of evolution. I know that there are also quite a few applications for new exchange traded products, whether those are ETFs or other products that could be used on exchanges. And this would extend into new types of tokens and just providing a lot more flexibility in that space and the ability to access certain crypto assets through a regulated wrapper that I think is much easier for investment advisors in particular, given the current custody rule and other requirements to access and go through, as opposed to seeking to hold Bitcoin or Ethereum or some other more exotic crypto assets directly. I think we're also likely to see the SEC to continue focus during examinations on crypto. I think that there's always a lot when we're talking about crypto assets to be thinking about, particularly when it comes to marketing. So, and this goes for both broker dealers as they're thinking about their obligations under FINRA rules, but also for investment advisors when we're thinking about their obligations under the investment advisor marketing rule. And we've seen a lot of enforcement actions in the marketing rule space of late, and I suspect that'll continue, and that we'll see some correlation to crypto exams as well. So that's something that we've been telling all of our advisors who handle crypto assets to be really focused on, and that we've been pretty laser focused in our reviews on. I think the final point is we're seeing an interesting emergence of new crypto, I'll call them crypto treasury companies. So these are companies that are kind of taking a page out of the MicroStrategy book acquiring large amounts of Bitcoin, Ethereum, or even more exotic crypto assets. And so I certainly think we've seen a boom in those. And I think the SEC recently put out guidance on what it expects to see in registration statements for those types of entities. And we're working with a number of our clients on those types of projects as well. I also think that there's going to be an interesting back and forth between, as exchange traded products more of them come onto the market, what is that going to do with respect to the treasury companies and everything else? And there's going to be an interesting intermix. And I think the SEC is going to be very focused on all of these different aspects of crypto as it moves forward with trying to bring crypto more within the existing regulatory structures while avoiding various types of customer harm. So there's just going to be a lot going on. And I think that if nothing else, you can expect a lot of activity out of the SEC when it comes to crypto over the next 6 to 12 months.
David, that's a super helpful summary. The reality is crypto's not new, and it's been on the market for 10 years in a lot of ways. But what we're seeing now is nothing short of transformative in terms of how the SEC's approaching it. And, looking at everything we've seen the SEC do in the last few months with the roundtables, and I think you've pulled together an amazing amount of developments sort of in a very succinct way. But I think what we're seeing is the SEC being very holistic about this.
Yeah.
And seeing where, all of the different touch points that crypto has with the securities industry, whether it's brokerage, whether it's advisory, whether it's the structuring. So it sounds like that is your point of view as well in terms of the acceleration effect and the transformation effect.
Yeah, I absolutely agree with that. And again, I think it's as things accelerate, as we continue to have dialogues, I think that the roundtables you talked about were absolutely fantastic. Having people from the industry, many times with disparate views on crypto, and hearing all of those disparate views and viewpoints, and really bringing new considerations to the fore for not just for the SEC to consider, because they could have done all of that behind closed doors, right? I think it was fantastic that they allowed the public in, and for people to hear very high level discussions about where crypto regulation was and where different people thought the regulation should go, including with respect to potential risks to customers and putting appropriate regulatory structures in place to help avoid customer harm. So I think that it's going to accelerate. It's going to continue. Going back to William's point about, staff attrition, things may not accelerate quite as fast as they would had we not seen some of the attrition numbers that we've seen over the course of the last couple of years at the SEC. But I think the fact that we're talking about these things, that we have solid proposals, et cetera, it really does give me a little bit more faith that, when Commissioner Peirce put out essentially a roadmap I think it was this February, I think everybody, including myself, was wondering whether or not we were going to see execution on that roadmap. And I think that particularly with these new proposed rules and the expected or the hoped for timing, we are seeing much of that roadmap start to come to fruition, as well as through less formal guidance from the SEC too.
No, it's very much everything's moving in parallel lanes, as opposed to, for a while, I think the focus was on, well, what is crypto versus how do you custody it? And now it's just all running on parallel lanes, both in terms of the thought leadership and regulator industry debate, but also what I'm going to call sort of interim and helpful guidance that we've seen from the staff in recent months. David, I wanted to crystallize one point on investment advisors because I really liked how you framed the idea of crypto with a regulatory wrapper. I think that is a really good way to put it, first of all. And secondly, I really wanted to get a sense, I can look across the client base I work with and see how crypto is being used. I'm sure you can do much of the same. What is your sense of how our investment advisors actually using crypto today, now that we have these exchange traded products that have more of a regulatory wrapper?
Yeah, it's a fantastic question. I think that a lot of people in the financial services industry, certainly a lot of institutions, are still approaching crypto somewhat cautiously. I think that the very good part of what we're seeing with the SEC taking affirmative rulemaking action is that I think we will start to get additional certainty, and the institutions will start getting more certain advice from their lawyers, which will then make them a little bit more comfortable when dealing with crypto assets. And I think the first sort of green shoots of that really were the approval of spot Bitcoin and spot Ethereum ETFs. I want to say back in, I guess it was back last year. And when that happened, I think that investment advisors, certainly client advisors and fund managers that I work with, started reaching out to understand a little bit more about crypto, because no longer did you have to have some complicated wallet structure, right? So like go out and get exposure to Bitcoin, to get exposure to Ethereum. You could start doing it just through your standard brokerage account. And while I know that there's been a pretty rapid acceleration of individuals getting into these crypto ETFs, I think that there's still a lot of potential for advisors to continue getting exposure for themselves, or frankly for their clients, to crypto through those exchange traded products and that regulated wrapper, which I do think can give institutions a little bit more comfort with these products. And honestly, we're still seeing, particularly from like a private fund advisor or exempt reporting advisor perspective, clients going directly into different types of crypto, including Ethereum, and maybe even some more exotic products, more exotic crypto assets, and dealing with the traditional, I'll call it, headaches of making sure that they understand how the wallets are working, they understand how their custodians are handling their crypto assets, they understand how they are going to go about trading their crypto assets on exchanges that often are not regulated in the same way as a securities exchange. And again, though, it's going to be interesting here as we move forward, as security exchanges like national security exchanges here in the United States potentially gain access to spot transactions in Bitcoin, Ethereum, and other products. It's going to be interesting to see whether that gives advisors a little bit more comfort. For now, I think that we continue to butt up against the custody rule questions that people have had for a very long time when it comes to crypto. But again, my sincere hope is that as we move forward and we're looking at amendments to the custody rules, that we'll be able to crystallize exactly what the SEC staff's views are on qualified custodians and things of that nature.
Incredibly helpful, David. But just to follow up on that, I know you had touched on this previously. An investment advisor is a fiduciary to their clients. We've talked about some of the use cases today, but can you maybe talk about some of the maybe unique challenges that arise if you're an advisor and you're recommending to your client or providing access to crypto assets that's maybe, somewhat different than a traditional asset class?
Yeah, absolutely. And interestingly, I think some of these concerns apply both to exchange traded products, and also to, for example, if an advisor was going to put one of their clients or itself was going to invest directly in ETH or Bitcoin. The first and foremost, you really have to be worried about product diligence, and then how are you going to monitor these products, valuations, and things on a go-forward basis. You also have to, as an advisor, be prepared to watch out for your clients, or explain to your clients all of the different unique aspects of crypto assets. And even with Bitcoin and Ethereum, which are probably the two most traded and best known, you're still going to have just rampant volatility in the prices. You got to be thinking ahead of the time and ahead of the curve about forks and airdrops. A fork is essentially where a blockchain, for developmental or other reasons, splits into two branches, and one branch kind of wins that split and people generally migrate over to it. But the other split may continue on for a while, and figuring out exactly how you're going to deal with that situation. Hard forks and airdrops, it can have kind of unique tax consequences, both potentially for the advisor and for its clients. There are still some, I think, restrictions around, or questions at least, around staking. Staking essentially is a way to generate additional yield from a crypto asset by tying up typically some of that asset and essentially you're being paid to rent your assets and for somebody else to hold them, vote them, and use them on a particular blockchain protocol. Trading halts because many times when you're trading these crypto assets, particularly if it's a little bit more exotic one, it may not trade all that much or as much on a US crypto exchange like Coinbase or someplace that might be subject to more regulation. So then you're looking overseas, and is that in the best interest of your clients? These are all the different types of things that I think you have to think about from a product diligence and ongoing monitoring perspective. Next, you get into custody and control realities. You have to start thinking about the qualified custodian point that we just made. If you're an SEC registered investment advisor, do you have enough comfort there that the SEC is comfortable with some of the very large crypto custodians providing custodial services for the assets? Or do you think it remains just a little bit too unclear? Sometimes that just comes down to a risk calculus and the size of the organization. You have to be thinking about books and records. How are you going to maintain those books and records when many times the evidence of ownership is contained on a blockchain? And so are you going to use a more centralized exchange like Coinbase or Kraken or others that may assist with that? Or are you going to really try to keep track of that yourself and through wallets that you personally spin up? That's another, I think, consideration that's a little bit different, but again, the gap is closing more and more as we have larger players in the space offering wallets and offering custodial services. Finally, or at least for this part of the discussion, you got to be thinking about conflicts. You got to be thinking about fees. You've got to be thinking about your marketing materials in the same ways that you would think about it for any product. But you got to make sure that, particularly in the marketing materials, that you understand the products that you're trading in. And there's some helpful descriptions, for example, of Ethereum or Bitcoin and many other products that you can find in the registration statements, for example, of exchange traded products that may help you kind of understand in a more plain English way the way that some of these products work. But there's a lot of products that are not yet covered by exchange traded products or exchange traded funds. And so you're not going to find them in those registration statements or descriptions. And so then it kind of comes down to you to either learn about that particular crypto asset and how the blockchain that it operates on works and what the unique risks are, or to hire people or pay professionals to help you understand that. So those are all kind of unique things that I think from a fiduciary duty perspective, advisors really have to be thinking about all along the way when they're talking about getting into crypto asset products. And finally, I'm probably going to keep going back to this, but again, the exchange traded products and exchange traded funds really help to cut through some of this because they have registrations and registration statements, because they're within the existing sort of regulatory wrapper and infrastructure. I think that makes them much more attractive to people who are just moving into this space.
David, that's incredibly helpful, especially since one of our goals today was to talk about how firms, whether broker-dealers or investment advisors, would want to prepare for possible SEC or FINRA examinations. And I think you've really set out a great checklist of things to think about, and this touches on all aspects of standards of care, fiduciary for investment advisors and Reg BI for brokers, and in sort of what all of the different components of a compliance program as applied to digital assets. So I thought that was tremendously helpful. I did want to touch for a moment on enforcement actions. I think we're sort of seeing at this point 2 to 3 categories. There's the category of what I'm going to call outright crypto fraud, which has nothing to do with this crypto renaissance or transformation that we're living through, that is very much about legitimizing and giving a path forward to the crypto and digital assets industry. Most of the enforcement cases I'm seeing have nothing to do with that. And then there's the second part of it, which is firms that are legitimately in the business of crypto, but may have not put in the correct safeguards to uphold their standard of care to their clients or customers, to ensure that assets are protected. So that's sort of the middle category. And then I think we have a third category, which is what is crypto really? So there's really sort of these three categories of enforcement actions we've seen. I think the first category is where we've seen the highest concentration, but I was hoping you could speak to the middle category or even sort of the third category, which is still a little bit definitional, and I think going to be overtaken by the work of the roundtables and the internal SEC process.
Yeah, I think that that's the perfect way to characterize it. I think, and I don't know that there's necessarily a correlation between the two things that I'm about to put out there, but we have seen a large number of cases that the SEC was bringing against very big names in the space, essentially shut down, withdrawn, or cleared out ahead of rulemaking around the definition of a security, what is a security, et cetera. And so while that may just be happenstance, it could also be part of a more organized move towards providing regulatory clarity to the industry and rules of the road on a go forward basis. And don't forget, we've also got Congress out there thinking about various proposals and everything else. And so while we're obviously the topic that we're focused on today is really SEC, investment advisor, FINRA for, FINRA and the SEC for broker dealers, there's a lot of movement in that space as well. And so I do think that we've seen a slowdown in the enforcement around that are dealing with, well, what is crypto and kind of the definitional questions and some of situations where I think depending on how bad the safeguard violation was, I mean, I think we'll still see cases in that space. But I tend to think that crypto fraud and cases involving clear investor harm and customer harm are going to predominate as we move forward in the next few years. I could be wrong, but that's the feel that things have, and also the fact that we have all these proposed rulemakings out there. It would seem a little bit disingenuous if you were putting proposed rules out and kind of saying that rules need to be clarified while simultaneously going after people for violations of the same rules. So moving forward, I think that the focus is likely to continue to be on crypto fraud and really to hone in on that. Although there will be, I'm sure, some cases where safeguards were just flouted so egregiously that the SEC feels compelled to take action, particularly where there's evidence of investor or customer.
And I very much agree with that, especially what I'm going to call the importance of safeguarding, which comes back to, where is the asset held? Where is it safeguarded? Is it with a qualified custodian? Is it held, on the blockchain, on a different platform, and so forth? That is core to investor protection when it comes to the use of what I'm going to call very legitimate crypto, as opposed to everything we're seeing in the crypto fraud realm. I did want to, before William asks you what we should be looking ahead to, I did want to ask if there was anything else you thought we should touch on the topic of custody and safeguards with regards to digital assets and crypto.
Yeah, I think that a couple things as far as custody goes. Again, if you're not really steeped in the crypto space, you're not familiar, maybe you're not even familiar with what the term wallet means, or what cold storage is, or a hot wallet, cold wallet, et cetera. Start within the legal wrapper. Start with an exchange traded product and start getting your feet wet that way. Develop your procedures around that. And I think that that's the best place to start because the exchange traded products are traded on exchanges that advisors will be familiar with, that are regulated by the SEC, if it's a SEC registered product, so on and so forth. So if you don't know what you're doing in the space, don't get in over your head, because if you do get in and over your head, that's exactly the space where I could see the SEC taking action. If, for example, you're an investment advisor who hasn't really been in the crypto space, you go out and you decide to self-custody some assets in a wallet that you have the private keys for. And for anyone who doesn't know, the private keys essentially control the wallet. If you lose those private keys, you lose access to all of the assets in that wallet. If you're an advisor and you do something like that, you just misplace them, or God forbid, you throw them away. I think there was a story out of Europe where a gentleman threw away by accident his keys, and then ultimately bought a dump to try to find them, to try to find the piece of paper that he had written it down on, and things like that. These stories are pretty ubiquitous. But if you're an investment advisor with fiduciary duty to your client and to your fund, and you do something like that, I think that that's an area that you could absolutely be targeted, and honestly, probably should be targeted by the SEC just for failing to look out for your clients. So I guess the overall thing there is, if you're not really into the space, focus on exchange traded products. As you get into the space, make sure that you have either the internal or external expertise, whether that's working with a consultant, a law firm, et cetera, to really understand all of the different types of storage, whether that's cold storage, multi-sig, all of these different things, and really know what you're doing. And to the extent you go kind of with the middle ground where you get a qualified custodian involved in order to hold the assets, make sure that you do your diligence on them too, because you need to understand what their protocols are, how they control access to your crypto, who has access to your crypto, whether you should set up some type of multi-sig arrangement where multiple people have to sign off on a transfer, et cetera. So that's custody is a big deal, particularly for advisors, which I think is why it's been such a focus of the SEC over time.
Thanks so much, David. This has been such an amazing conversation. And just an important follow up, I did read a recent story that unfortunately the gentleman did give up his search. So unfortunately, he was not able to track down his USB stick in the dump, but
Yeah.
it definitely gives you a really good illustration of how important that security is, because once it's gone, it's gone. So, I definitely think that's a huge takeaway here. But, as Valerie said, kind of looking forward, and just because we have you on here with your expertise, if you could give just kind of one piece of advice, say I'm an advisor, broker dealer, really looking at these crypto products, I see the way the administration's moving. I've never seen this before. My clients are asking about it. What would that advice be?
Yeah, I think for an advisor in particular, again, that's getting started in this space, start inside the regulatory perimeter and start building out your compliance program based on that, and then expand over time and get deeper into crypto over time if you want to do that. But after you have designed your governance, disclosure, marketing, incident response procedures, and you've got everything down that you think you're going to need just for the exchange traded products, which honestly probably will not be that much beyond what the advisor already has, although I do think you should have tailored disclosures for that. And I think also when you're dealing with these exchange traded products, you're going to get to see kind of how Bitcoin acts and how Ethereum reacts and acts on the market. You're going to have a sense of what disclosures you need to be providing to your clients when it comes to volatility and all those other things. And once you have that in place, I think moving on to something a little bit more interesting or that may have a little bit more of an upside or profit potential makes sense, because you've mastered one area and you've understand how Ethereum and Bitcoin, or Bitcoin, I should say, work as much as any of us truly understand it outside of the quant community. And then you're much more ready to go. And it's also a much more defensible position, right? If the SEC comes in or FINRA comes in and is asking about your crypto business, it's much more defensible to say, well, we ramped up and built to this, as opposed to just sort of trying to jump on the racetrack going 150 miles an hour without any guardrails and a lack of certainty about what the future holds. And I guess the last point, that was my main point, but the last point is I don't think that people should be afraid of crypto. As Valerie noted earlier, crypto has been around for a while. And I think that there is an acknowledgement now that crypto is coming a little bit more into the limelight and a little bit more into the spotlight. But I do agree with what the SEC is doing right now in trying to put appropriate guardrails around transactions in crypto. And I think that as we move forward, we're just going to be in much firmer footing for many of our institutional clients in particular, and that people who want exposure to crypto will just have more and more options to get that. And so for me, it's a very exciting time.
Great. Well, again, this was such an amazing conversation, David. Thank you for coming on, really kind of diving in, providing your expertise, talking about these different issues when it comes to crypto assets. I think it is, again, going to be kind of the theme of the day. Again, we've seen the administration, we've seen government agencies, but I also think, to one of your points previously you made, David, it's also going to be kind of more mainstream. As Valerie said, crypto has been around since the late 2000s, but now it's really becoming something that, we're seeing members reaching out to us saying, hey, clients are actually asking about this. What do we do? So I think it is critically important to educate yourself, and this has been a great example of that. So thank you.
Yep, my pleasure. Thanks for having me again.
Thank you again, and till next time.